Next up, we're going to get a legal update from two incredibly talented groundwater lawyers. First, we have Deborah Trejo. Deb is a partner at Kemp Smith Law Firm, and joining her is Greg Ellis, who's an attorney at GM Ellis Law Firm. Please join me in welcoming them up here.
Good morning, everybody.
Good morning.
All right, we are going to talk about some current legal issues that are very active in the state. We're focusing on litigation and also going to talk a little bit about appeals of actions taken by GCDs. So here's our kind of list of things that we're going to cover. We're going to talk briefly about contested case hearings and some of the issues that are bubbling up around the state that I think are important and I want to point out for you all. We're going to talk about litigation generally and what that kind of looks like for groundwater conservation districts, specifically looking at enforcement issues and defense against challenges to district actions. We're going to talk about a couple of very specific cases, the Blaine Larson Farms versus North Plains GCD case and the Aqua Texas versus Hayes Trinity GCD case, the Cockrell case versions 1, 2, and 3, and then the LCRA versus Lost Pines GCD litigation as well. So I'm going to get started, and then I'll do my section and then go to Greg's section, and hopefully we can leave a little bit of time for you guys. I'll just keep looking at my phone, but we've got a total of 45. Okay, so let's see. I don't want to go more than 20. Okay. All right. So first, let me just bring up some things to you all about contested case hearings. District rules authorize certain applications to have a contested case hearing, which is an adjudicative court-like proceeding before a groundwater conservation district board, an administrative law judge, or the State Office of Administrative Hearings. But note, district rules. So this is something that districts themselves, per Chapter 36 of the Water Code, determine which kinds of matters are going to be entitled to have contested case hearings. It's not something absolute set forth in Chapter 36. It's up to districts to say what's going to be entitled to a contested case hearing and what is not. So you need to look at district rules to see what kinds of applications or matters are going to be subject to that kind of a process. Chapter 36's language really contemplates that is in the permit domain. It's in the context of permitting decisions. Some districts do have the option for contested case hearings related to, for instance, other things like enforcement matters, but that's truly within the discretion of GCCs to do. Chapter 36 seems to contemplate that would happen only in permitting matters. So what that might be contested cases around is up to districts to decide, but look at the rules and you'll have to determine that. But as GCDs adopt and implement rules to manage groundwater, which is primarily through requiring and managing permits to withdraw groundwater, they're proposed in some cases or issued permitting decisions are being protested in contested case hearings. And the emphasis here on proposed or issued permitting decisions, because it looks very different, and the Water Code has some very confusing language around what is being protested exactly and the timing of that. But for example, you might have a general manager recommendation on a permit with a draft proposed permit, and that is what you protest. Or the board may take action on a matter, and what goes to a protest and a contested case hearing is the board's decision. But when you have a hearings examiner at SOA or separately hired or the board itself, they're reconsidering whatever was being protested, right? So if the general manager made a recommendation on a permitting decision, then that's being protested, and the board will consider recommendations on what do we do now based on this record. Alternatively, the board may have ruled already and, for instance, granted a permit, and that's appealed to SOA or some other proceeding. for a contested case, and then the board is reconsidering what it does. So it may look very different, so you sort of need to look at rules. And for a lot of districts, these are new proceedings. They've never had contested case hearings before, and a lot of this stuff is kind of being worked out in the process. Okay, when reviewing permits, Chapter 36, and this was mentioned by an earlier speaker today from Gonzalez GCD, Chapter 36 requires that groundwater districts consider, among other things, whether an application would be for beneficial use without waste. Will it not have unreasonable effects on groundwater and surface water resources or other permit holders? Will not be inconsistent with the district's management plan, which, by the way, Chapter 36 requires to provide for the most efficient use of groundwater, nor prevent the district from achieving the desired future conditions for the relevant aquifer. So all of those things are required things for the district to consider in granting or denying a permit. They're not optional. So they're part of the mix of, do we give you this permit or not? Matters that are currently pending before the State Office of Administrative Hearings and contested cases, challenging a groundwater conservation district permitting recommendation or decision have involved issues like finding whether applicants have or have not established the need for the requested amount of water for a specific beneficial use, and whether issuance of a permit will unreasonably affect existing groundwater resources or permit holders. Now, let me kind of clarify that a little bit. I wanted to point out to everyone here that some of the things that are currently being considered by the SOA in contested case hearings involving groundwater conservation district decisions include whether or not you can have an application that is for some possible speculative future use. Maybe somewhat defined, but not very specifically defined. And whether that's all you need to say is, for instance, I want a permit for ag, with no crops, no plan, no farming happening on your property. Is that beneficial use? And the argument is being made that, yeah, all I have to do is say the kind of use I have, municipal, industrial, and I've checked that box, and you have to give me a permit. But what's important to note is that the water code and district rules require that to be for an amount of water. So when a district is reviewing an application, it's, well, how much are you asking for ag use or municipal use or industrial use? And do you need that amount? And if you have no plan and it's purely speculative, I'd contend that you haven't really established beneficial use without waste. And so if you look at the Guitar decision, for instance, where use included both purpose and amount, beneficial use, is it enough to just say general broad category and you're entitled to water without a plan? So these are issues that are currently pending before SOA in contested cases, and I think we need to keep an eye on what comes out of those. And then once those decisions, recommendations, proposals for decision are issued by SOA, what are the district boards going to do? How are they going to take those orders, however they come out, or are they going to make modifications based on their rules and their belief on what the district has to consider under Chapter 36? All right. And so, for instance, these are some of the arguments being made. A GCD determination of administrative completeness for processing, so that you filled in the application and provided the relevant and required attachments, equals a finding that a permit is entitled to be granted. Without a district being able to consider the requirements of Chapter 36, mandatory requirements, in Chapter 36 in permit issuance, or public input in a contested case. So how could it be that just submitting an application for administrative completeness, and I want to address that you have to say yes at all times. What if you have an application to, I don't know, use water from an aquifer that has no water in it? There's no water to grant you because there's no water there. Right? I mean, it's been at your location, it's no longer has water. So we have to give you a permit for 1,000 acre feet, even though there's no water. That doesn't make sense, right? Or let's say it's for an illegal use. You have an administratively complete application, but it's to do something illegal that violates state law. We can't say no? That doesn't make sense. It also wouldn't make sense to have the right to contested cases and for applicants to bring forward evidence of unreasonable impacts. I mean, not applicants, but protestants. So let's say cities and communities that are in a location where a permit is proposed, if there's an opportunity for contested case, they bring forward their evidence. This is going to impact me. Here's what we know about the way the aquifer works, et cetera, et cetera. If administratively complete applications mean you're entitled to get exactly what you asked for, then why allow protestants to bring forward evidence? That can't be what the legislature intended, right? I mean, the whole idea is you file an application, now you've teed it up for a district, now we look at it, we do technical review. And we figure out, oh, well, and we let other people come forward with their science, their evidence, their information, and then the board and the district is able to make more complete decisions, right? Public process, open meetings. So I think these arguments that are being made right now that administratively complete equals entitled to be granted are not consistent with administrative law and are inconsistent with the statutory scheme. But these things are currently pending before SOA right now, and we'll see what SOA recommends. And I already mentioned this one, listing a category of use with no plan or specificity of the need for the requested amount of water is adequate. That's all we've got to show. Just check the box, put in a type of use, and we're done. Okay, so litigation. So now that's contested cases. Now let's switch to after a contested case or independent of a contested case, litigation. So GCDs can be involved in all kinds of litigation, like anybody else, right? That can involve contract disputes, employment issues, real property. Chapter 36, though, expressly provides for contested case decisions to be appealed to district court and for districts to enforce their rules and seek civil penalties and injunctive relief in district court. So let's talk a little bit about that. There are suits against GCDs challenging permit decisions or the application of rules. So parties to contested cases can challenge those decisions and seek judicial review. And permit applicants and others can sue GCDs challenging a variety of actions under a variety of laws, including declaratory judgment actions. And this is a popular one. I have several cases now that involve DJA challenges to district action, district rules, but claiming that district action is unauthorized or ultra-virus. All right. So that's just a little bit of background. Some of the stuff is kind of out there and bubbling. Now we're going to talk about some just very specific cases that you might be interested in. And I'm going to talk about these two cases that are very similar to each other. The Blaine Larson Farms land versus North Plains GCD case. So the North Plains Groundwater Conservation District regulates groundwater withdrawals in several counties in the Panhandle, primarily from the Ogallala Aquifer. The district rules require well spacing and limit groundwater withdrawals to 1.5 acre-feet per acre within what's called a groundwater production unit, or GPU. And this is a tract of under the rules, a tract of contiguous acreage of up to 1,600 acres, which is owned by a permittee. BLF is a corporation that holds permits from the district to withdraw groundwater from the Ogallala Aquifer for agricultural production, potatoes, on part of more than 50,000 acres that it owns. BLF has repeatedly violated the district's rules by exceeding the authorized amounts allocated to its groundwater production units, concentrating its pumping in only a few sweet spots on its property where it has very productive wells and creating a cone of depression that has impacted adjacent landowners. So basically, under the district rules, they have sort of an administrative 1,600 acre management where within that 1,600 you can use 1.5 acre feet anywhere on the property. On average, it can't be more than 1.5 acre feet per acre, but it's within those kind of management units that you do reporting. And that's a rule they've evolved over time to sort of, it's like an addition to spacing rules. They also have spacing rules. Because this entity, BLF, has pipeline that can move water anywhere it wants on its property. It has wells everywhere, and it could use them everywhere. But it chooses to use the most productive parts of places it's got the best wells to do all of its pumping. So it's just creating massive cones of depression at those locations. They've also committed another 100 violations of the district's rules related to metering, well construction, and other things. In the past, they've paid the district a monetary settlement for their overpumping, but they've just decided that they don't have to comply with the rules anymore, and so they're not settling their violations and they're not coming into compliance. And there's no time, they're not indicating they want to, so we don't expect they will be. In August of 2023, before the district filed an enforcement suit against BLF, after sending them enforcement letters saying, hey, come into compliance, you're overpumping again, settle your past violations and reduce your pumping within these GPUs, the BLF affirmatively filed suit against the GCD in federal court in the Northern District of Texas, asserting that the district's rules are unauthorized by law and that the district's enforcement of its rules constitutes a violation of BLF's civil rights to equal protection, due process, and results in a taking of their property. The district filed a countersuit, bringing the enforcement claims for all of their violations, and that suit is currently pending. So you'll see that this story gets repeated in this case. So Aqua Texas versus the Hayes Trinity GCD. And I know this has been talked about, and if you're in the Austin area, it's been in the papers a lot. It's been on the radio. It's very much of a hot button case that people are hearing about. And I think hearing about cases like this is a really good thing. Because we need to know what we're up against in terms of being able to protect groundwater supplies in the state and whether or not GCDs are able to enforce their rules, right? So the Hayes Trinity GCD is in the southwest part of Hayes County, and its jurisdiction includes Jacob's Well, which is a spring-fed amenity which receives its source water from the Trinity Aquifer. The district has created the Jacob's Well Management Zone to monitor and protect Jacob's Well. Due to persistent drought conditions, the Hayes Trinity District has required reductions on permitted withdrawal amounts to conserve groundwater, including special regulations requiring reductions in the Jacob's Well management area. Aqua Texas is a for-profit corporation, which is national, with a certificate of convenience and necessity that holds permits from the district to withdraw groundwater from the Trinity Aquifer in Hayes County, including within the Jacob's Well management area. And right now, actually, they only own permit because 6 out of 7 of their permits were not renewed because they were in an enforcement context with the district. Aqua has violated its permits from the district by overpumping its authorized amounts in 2021, 2022, and 2023, and it has committed numerous late reporting, waste, and other violations of district rules. And I'll note, I mean, they had prior violations too, they just were resolved. The district has attempted to avoid suit and get Aqua into compliance, and has tried to resolve Aqua's violations by offering to accept a settlement of the district's civil penalties claims for the violations. Due to the pending, I already said this, 6 of the 7 permits weren't renewed and expired at the end of 2023. But in December of 2023, right before the district filed an enforcement action against Aqua, Aqua sued in federal district court in the Western District of San Antonio, and so Western District of Texas, Austin Division, the district. So, same movie, right? We're violating rules, we're overpumping, and we're going to sue you for violating our civil rights. I'm not really sure how their civil rights were violated because I'm not really, I mean, the district had not taken any adverse action against either Aqua or BLF, right? I mean, we said you're violating our rules, but there was no action. Their pumping has continued. Their willful violation has continued. Sort of an interesting civil rights claim, if that's what we're worried about on civil rights. I'm not really sure. This is, these claims, kinds of civil rights claims, due process, equal protection violations have been alleged against GCDs before. I've defended those suits successfully. They just sort of copied the same prior litigation that was unsuccessful in these cases. But here we go. So the suit asserts that the district's enforcement of its rules constitutes a violation of its civil rights to equal protection, due process, and results in the taking of its property, and that the district's settlement schedule and moratorium on applications during drought is invalid. Aqua has also asserted that because it is required, Aqua Texas, because it is required to provide water to its customers within its CCN, it cannot also comply with the district's rules limiting production to permitted amounts. This is a big deal, and this has been a lot of the reporting. Basically, Aqua is a utility, so it has to provide water to its customers, continuous and adequate service, right? You utility lawyers know this, and folks dealing with public utilities know that. But does that mean you get to violate other laws in the process? Because you have to get more water, conserve water, or decertify part of your CCN if you can't meet all your customers' needs. But it's not that, I don't believe the state intended to give Aqua or any utility a blank check to violate all other laws because you have to serve your customers. So that is in play in this litigation. I do not think it is a good argument, but it is the argument that Aqua Texas is making. The district also filed a countersuit for Aqua's multiple repeated violations over years, and that suit is also pending.
Every time there's a lawsuit, lawyers will attempt to resolve those lawsuits as quickly as they can, if they're especially on the defense. And you'll find that courts tend to look to procedural matters before they look to the substantive matters, because it's a lot easier to decide these things on procedural grounds than it is on the substantive grounds, which is why we don't have a lot of answers to the many, many questions that have been raised by various lawsuits and various arguments being made around the state. These cases I'm about to mention highlight that. The Cockrell cases all came out of Fort Stockton against Fort Stockton Holdings, where the district there in 2009 received an application. They had a contested case. They denied the application. That got litigated. As part of that litigation, they eventually reached a settlement. Cockrell had to then, Cockrell did not at that time protest those applications. And this is an important thing here, folks. The only way you can protect your rights on your property is to pay attention to what your neighbors are doing, and if necessary, protest the permits being requested by your neighbors. And I understand how difficult that can be for people, but it's absolutely critical to maintain your rights. If you don't file that protest, you're virtually cut out of the process from that point on. So Cockrell here did not protest the applications filed by Fort Stockton Holdings at the time they were filed. So in 2017, after they reached this settlement as part of the litigation ongoing with Fort Stockton Holdings, the Fort Stockton Holdings filed an amendment to that application. The district granted the permit, had a final hearing on that and granted the permit. And at that time, Cockrell came in and tried to file a protest against the amended application. The district denied that request for party status and said, no, your chance to file that protest was back in 2009. It's way, 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 way too late. And so we're not going to put you in this process. You can't do that. The time to file a protest is long past. Cockrell has since that time now filed 3 different lawsuits. Cockrell 1 was challenging the district's decision denying its party status and appealing that district's decision to issue the Fort Stockton Holding permits. Cockrell 2 was a challenge against the district's renewal of the Fort Stockton Holdings permits, and Cockrell 3 is a declaratory judgment action challenging the district's future renewal of Fort Stockton Holdings permits. Now let's talk about Cockrell 1. After the district denied its request for party status, Cockrell filed a motion for reconsideration. Now the district rules stated that motion would be denied by operation of law after 45 days, and the statute requires that a lawsuit be filed within a certain number of days after that motion for reconsideration or rehearing is denied. The trial court, after they filed their lawsuit, the trial court granted the district's plea of jurisdiction, which said they didn't meet the deadline, and Cockrell filed an appeal of that. The 8th Court of Appeals then held that the trial court did not have jurisdiction to hear the appeal because Cockrell failed to exhaust its administrative remedies, meaning they failed to follow the statutory deadlines. Although they had followed the district rules on the 45 days, they didn't follow the statutory provision that required 90 days before the motion for a rehearing is dismissed by operation of law. So they waited the 45 days, then they waited another, shortly after that, within the 20-day limitation, they filed the lawsuit. That was way, way too early because they had to wait 90 days. That's what the Eighth Court of Appeals said. So Cockrell has since filed a petition with the Supreme Court of Texas. That was back in October last year. And on June 14th, the Supreme Court requested briefing on the merits, and that is underway. Now, the Supreme Court will either grant or deny a petition, but they can frequently, and do frequently, request a full briefing on the merits of the case before they decide whether or not to grant the petition. So the petition has not yet been granted. We'll see if that happens after they get all this briefing in. In the meantime, the permit came up for renewal. And so while that's working its way through the appeals process, 36-122 of the Water Code requires the GCD to extend an export permit term from 3 years to 30 years once construction of the conveyance system is started. Now, I have to admit, I don't know how you start construction to conveyance. I mean, I'm picturing a guy with a shovel out there turning a piece of dirt, and they said, we started construction, we now get a 30-year permit. And that'd be kind of hard to argue that they're wrong about that. Just roll a backhoe up and dig a hole, and you've started your construction. In any case, Fort Stockton Holdings, for whatever reason, has not started the construction, so they had their 3-year permit. And the other thing is that the district, in that case, issues a combined operating and export permit. So it's just one permit. That means that the operating part of that permit certainly is governed by 36-1145, and it requires automatic renewal of that permit when it comes up for renewal, unless there's enforcement actions or other things that would interfere with automatic renewal. And that meant that because it's a combined permit, they also authorized renewal of the 3-year export permit. Cockrell said, no. We don't think you should be renewing the permit, and you certainly should not be renewing the export permit. I want a hearing on this issue and want party status in it. And they said 36-122 is the only method for extending the export permit. If you haven't begun conveyance, your export permit dies and you have to reapply. That's their argument. So following their denial of party status on that, they filed a motion for rehearing. Once again, they followed the district rule requiring only 45 days. Then they filed their lawsuit. And again, this made its way up to the district court judge denied or granted the plea of the jurisdiction. It went up to the Eighth Court of Appeals. Eighth Court of Appeals again ruled you had to wait 90 days. You didn't do it. So because the motion for rehearing had not yet been denied, you filed your lawsuit too early, and that's failure to exhaust your administrative remedies. The Court of Appeals also, in that case, held that Cockrell's claim seeking a declaration on the merits of the district's decision to grant the 2020 renewal was barred by sovereign immunity because only a party to the first initial contested case can challenge the permit decision by the district. So if you weren't a party in the first one filed in 2009, you cannot come in later and join as a party to challenge the permit's renewal later. Cockrell filed the petition also with the Supreme Court, again, also last October, and on June 14th, same day as the other one, they requested full briefing on the merits. And again, this petition has not yet been granted, and that briefing is underway. Well, in Cockrell 3, they took a different route altogether. In March, they filed a declaratory judgment action and said, we want an injunction against the district and Ty Edwards, the general manager, from renewing this permit because we don't think that it's legal. It's ultra vires act for them to renew this permit. That suit argues that 36-122 provides the only means of extending the term of the permit, and therefore it's ultra vires to do that, and asks for a temporary injunction to prevent him from automatically renewing the permit. That was being considered by the court at the time the permit came up for renewal, and Ty Edwards renewed the permit. They filed a lawsuit on that, the lawsuit was already filed, so Ty at that point then filed a plea of the jurisdiction asking to dismiss that lawsuit, as did Fort Stockton Holdings after they intervened in the lawsuit, and the trial court granted both of those. Cockrell filed an appeal of that. Again, it went to the Eighth Court of Appeals. That Court of Appeals in that case has been fully briefed and is now waiting on the court's decision. So we'll have to see if the declaratory judgment route works better than the try and request party status and appeal route did. The second case I want to talk about is LCRA versus LPGCD. In fact, there are two of these. I'm only going to talk about one of them. One of them is a challenge against the district rules. This one is an appeal of the permit decision, however. In this case, LCRA filed applications for operating and export permits seeking to withdraw 25,000 acre-feet of water per year. By the way, I've had litigation over 75 acre-feet of water. So the fact that if there's the number of zeros is kind of making your head spin there, I can understand that. But believe me, people will fight over drops of water in this state. Multiple parties filed protests against that application, and the matter was referred to the State Office of Administrative Hearings, and they had an evidentiary hearing. Following that, they issued a proposal for decision that granted the permit for the full amount or recommended granting the permit for the full amount with certain conditions, and the board then conducted a final hearing. Following the final hearing, the board then voted to grant the permits but limited the operating permit to 8,000 acre-feet, based primarily on the fact that that was the maximum amount that they could put to beneficial use during the 5-year permit term, and the evidence in the record showed that that amount would allow them to continue to achieve their desired future condition. LCRA filed a motion for rehearing, and the board looked at the motion for rehearing, decided to grant the motion for rehearing. They took the matter back up on rehearing, issued a new final decision. They still limited the permit to the operating permit to 8,000 acre-feet. They granted the export permit at the full 25,000 acre-feet, and they kept the additional special conditions. LCRA then filed a second motion for rehearing on June 7th, 2022. While that second motion for rehearing was pending, LCRA filed a lawsuit in district court to appeal the board's final decision following the expiration of the first motion for rehearing. LCRA then amended its suit after the second motion for rehearing was denied by operation of law after 90 days to incorporate and recognize the overruling of the second motion into its suit for judicial review of the district's final administrative decision. So they really did try a belts and suspenders approach there. They filed the first one just in case they had to have that one done following the first motion for rehearing, in case somebody argued, for example, they couldn't file a second motion for rehearing. And then they amended that one following the denial of the second motion for rehearing. Several of the protestants intervened in that lawsuit, including Recharge Texas, and the Lost Pines GCD and Recharge Texas both filed pleas to the jurisdiction, citing the environmental stewardship case. Now, let me tell you about that case real quickly. That was an earlier case where environmental stewardship was denied party status. They waited until the permit was finally issued by the board, and then they challenged that in court. And there the court said, no, your problem is that you went by the 90 days here, and this was a case that was heard by SOA. Because it was heard by SOA, the Administrative Procedures Act applies, and so there's a 55-day limit for the motion for rehearing, and you missed the deadline there by filing this lawsuit too late. So environmental stewardship lost that case on the basis that they filed their case too late. So here, Lost Pines relied on that case and said, no, because this was a SOA hearing for this one, you only had 55 days for the motion for rehearing be denied, and you waited too long after that to file your lawsuit. The district court denied those pleas to the jurisdiction. Lost Pines filed an interlocutory appeal with the Third Court of Appeals. That question before the Court of Appeals was which deadlines apply, the Chapter 36 deadline or the Administrative Procedure Act. Now, LCRA argued that the NDOP decision, the environmental stewardship decision should apply because both cases were referred to SOA, and therefore the Administrative Procedure Act deadline should apply. LCRA argued the APA provision only applies to evidentiary hearing before SOA, and once the matter moves to final hearing before the board, the Chapter 36 deadline should apply. The Third Court of Appeals opinion was issued about a month ago, a little over a month ago, and said the court is bound by the prior court decisions. This three-judge panel is bound by that prior decision. Therefore, the environmental stewardship decision controls this case. And because SOA conducted the contested case hearing, the Administrative Procedures Act's 55 deadline applied, and therefore the lawsuit was filed too late. However, two of the three judges on that panel urged LCRA to ask for reconsideration en banc, meaning the entire Third Court of Appeals, so the full court could then overturn the environmental stewardship decision and say that was badly decided, and that 90-day rehearing deadline should apply, not the 55-day in the APA. And that has happened. LCRA has filed the motion for reconsideration. The district has filed a response. The LCRA reply has either been filed or is due very, very shortly. And we'll see what the full Third Court of Appeals does with that. They may deny the motion for rehearing en banc, or they may take it up. If they do take it up, they're going to go through a whole new round of briefing and likely oral argument there as well. So on this one, stay tuned. Now, I do want to say this as well. Challenging a permit decision is very, very difficult. You're going to have to prove that typically that the district didn't follow its own rules or the statutory requirements when it made that decision on that permit. But the ultimate result in that is not an order from the judge ordering them to issue a permit. The ultimate decision in that is from the judge saying, you go back to them and you tell them they have to do it again. They got this part wrong. They have to do that right and do it again. So you're back in front of the board that you just sued saying, we still want our permit and just do it right this time. Now, there's very little in the code that's going to say you're guaranteed a certain amount of water. There's very little in rules that say you're guaranteed a certain amount of water. Most of the rules that even allow for a certain amount of acre feet per acre include it has to be put to a beneficial use. It has to be, it has to meet all the other requirements of the water code. So just because you own 100 acres doesn't mean you get 1.5 acres per acre or 1 acre foot per acre. You have to prove up the other sections of that to say that you're going to get a permit. So in my opinion, what you should be doing is you should be doing everything that you can to work out a settlement with the district and the other protestants to get your permit. Because when you file that lawsuit, in the end, all you win is a right to go back in front of the board and ask them again for that same permit. So if possible, find a way to settle this for the good of everybody concerned. I appreciate your time. I very much appreciate all you staying. I'm going to take just one moment here of personal privilege to say I believe this is going to be the last time that we have a working Bill Dugat with us, and he has been a long time GCD attorney. He is one of the best attorneys in the state on that issue, and we are going to sorely miss Bill Dugat. So, Bill, congratulations on your retirement, and thank you for your time. The good news is we have young people like Deborah coming up along the right way, and she's going to do a great job too. She's already done a great job for EAA client and all of her clients, and I really appreciate her time up here. Thank you all very much for your time.
Yeah, thanks everybody. Appreciate it.
You too. All right, thank you all very much. Do we have any questions for our dream team up here? Yes.
Flow chart on what?
They may charge you, though.
One thing that I wanted to point out is that one really problematic thing about contested case hearings is that districts do not get necessarily reimbursed for those. And they're expensive. It's full-blown litigation that goes on for about a year usually with expert reports, experts, lots of costs. And I do think that's something we ought to see if we could get the legislature to have the district recover fees for. It's a very expensive process. And I say that because it goes to Greg's point. If we can work things out, if we can come to compromises, it would save everybody a whole lot of time, energy, and money. But it's also important to point out, not everybody is playing ball and not everybody is reasonable. So you got to also be willing to stand by your principles and do the right thing regardless of costs, right?
And let me add this to that. In some of these cases, it doesn't matter what you do, somebody is going to think what you've done is unreasonable. Especially if there are protests filed against the application, the protestants don't want it issued, the applicant wants it issued. No matter what you do, you're likely to be in trouble. I like to compare these cockerel cases because this is billionaire versus billionaire, folks. Cockerels are billionaires. Fort Stockton Holdings, the Clayton Williams family, billionaires. It's like having two heavyweight prize fighters in a fight with the district in the middle as the referee, but both of the fighters are punching the referee, okay? You GCDs are the referee in this case, so sorry about that. Any other questions?
Let's give you your time.
Thank you again for your time.
Thank you very much.